Let it be fixed on Monday, public proceeding. Returning on Sunday. Let it be fixed on.
I'm filing the bail application on the
Bill, my lord, the judicial custody lasts for 560 days if completed, my lord.
500?
560 days if completed, my lord.
Ask him to be here with the case diary.
Yes, let it be on Monday, it will be present.
The 10, mostly 10 bits is completed.
Let the matter be taken up on Monday. The
My lord, my senior appears for the petitioner, my lord. We have filed our reply and also sent this to the respondent also. My lord, we are seeking for time for hearing.
what time to hearing? It has been listed. What time?
May be taken up to the next settlement.
Why? Why next circuit? When everything is complete?
And my senior is also not physically well to come to the court, my lord, last 3 weeks, my lord. Because he might come from Chennai from treatment, my lord.
As prayed by the learned council.
Item 3, automatic application over 2 of
But I have compared the 4 paper books, my lord. I have page number 8 and I given that has been corrected in that respondent copy also, my lord.
So we are now all on the same page.
Yes, my lord.
Yes.
Hopefully, my lord, there should not be any pages missing because we have compared so that it can be.
Let's see.
Yes.
Thereafter, I will come to. Time of page
8. Clause 4 of NIT. That you already placed. Yes. Clause 4 you have placed, contract amount you have said, the contract amount includes the 15%.
That is page 24.
That, no, 44.
That is instrument page was different. Today page is itself.
So today the paging has become 8 instead of 7. 44 has become 45. Huh? 24.
That is the reason
Yes, 24.
24 2x. 2x.
24 2x you want to read with page 45. 24 2x you want us to read with 45 or 46. Yes, 46. Now it is 46. 46, yes.
The contract value is 6 crore.
Correct.
The period was 9 months.
9 months. Contract period.
Page 166 to 167.
And 61 to 76. Yesterday you had also placed page 63 to now renumbered page 78. why you were referring to these pages from 63 to 78? The terms of the contract, something you wanted to show, that is where we stopped. Oh, that is where, oh, that is why we stopped. That is where we stopped, yes. So what is the page, correct?
166, 167, just I want to show. The English, the contract is admitted in class one. That means the tabular form. This is the class one contract. Then. When I want to draw
What is there in 166?
166, the status of the contract in the class one enlisted contractor. That is the highest class in epidemiology.
Hmm.
Then page 217 to 222.
These are the resources you say you have deployed.
Excavator, vibratory converter, and others.
No, these are all of 2001, 2007, 2008.
Yes, purchase. Registration. This is the registration book, RC book. Yes, purchase. He was having all these vehicles.
So this is long before the NIT also.
Yes, sir, long. You are having those plans.
That's all right.
And not only one, there are other sources. Some different dates are there.
Let us see which is the contemporaneous date, bearing the contemporaneous date during the period of the contract.
That is that, on 2007, we have procured.
No, we are asking you contemporaneous to the contract period. After execution of the agreement is dated.
Yes, these also one.
What is the date of the agreement, sir? First, give us the,
Agreement is 10.
no, can you give the date?
1st December.
For 1/12/2010. So after 1/12/2010 or in close proximity to 1/12/2010, is there any document? Is any document which you have relied upon bearing a date in close proximity to 1/12/2010, based on which it may be inferred that it is an expenditure incurred
That is
in reference to the execution of the agreement?
taken on these on 14th March 2011, that is at page 218.
Yes.
Later. Dated 10/4/2012.
Yes,
After analyzing.
just a minute. Yes.
Then, this come to page 237,
So 338 only.
dated 16/4/2012.
Two 36 and 237 are the same documents.
Continuation of the
237.
237.
Lord, I think it also in 358 also, my lord. The page is the particular annexure is in 358 also. Not 358, the document is also enclosed in 358 also. But that document is in 358 also, my lord.
Said, my lord, may come to
358, same document is 358 now.
But you have not enclosed the documents with the letter. You have not enclosed any.
Uh,
Class one contractor.
Therefore, despite the
Yes.
economics 7 pass. Because of the course of.
He seems to be writing a very good letter. So therefore,
Their
therefore,
wisdom,
correct,
whatever they have written.
correct. So he is relying upon his employees and they are not annexing anything.
As per his instruction of the opposition, citizens have gone.
So there is nothing other than this letter to show that.
Page 239.
Yes.
The foreclosure letter after 4 years, 3 months, 3 months, 3 days. That is since 2010. This how they have foreclosed, despite knowing fully well that clause 3A is not applicable. There is another clause in the agreement, clause 13, which says the government can at any time abandon the contract. They did not do so. That is my next. 251 to 283. The balance sheet and income tax return file from 2010 to 2011. It is not the case that the petitioner had other foregoing works were there. New works were there. So
So 251 is for the financial year
10
2008,
and 11.
9.
10 and 11. Assessment year.
Where is it mentioned?
Assessment year on the top right side, 2010 -11.
10, 11, yes. So therefore, we said it is for the financial year 9, 10.
9, 10.
This is reflecting the affairs of 2009, 10.
Here, then coming to the.
And what is there in this that you want to take advantage of?
I don't, I just mentioned these documents continuously are given for the period. 2011 12 kind.
No, but for what purpose? You may give 100 documents, but what is the purpose and what is the point you want to establish?
Cost total income was 26,69,729. That is on top.
Yes, yes. Yes, yes. No, so the balance sheet does not show any loss. Rather, it shows a profit.
Then kindly come to. Page 253. And on page 253.
Yes. This is much prior to,
Yes, that's why I am to show that what was the profit he earned. Page 253.
yes,
After that, what had happened?
page 253.
Gross profit
Yes,
was 1 crore 93, 57, 54.
yes.
Then kindly come to page 254. This assessment year 2011-12. Page 254.
Gross profit and gross total income are two different things. They are not one and the same thing. So therefore, you cannot compare two parameters to show that you have suffered or incurred a loss. Just compare the same parameter. Where is the balance sheet for the next financial year? Must be enclosed.
11, 12.
Yes.
Here gross total income was 74 lakh 92,002.
So it has increased. So it has increased a lot. No, no, you come to page 251. What is the gross total income there in the earlier year?
2,56,000.
No, no, 26 has become 74.
No, not 74, 7,49,258.
All right, yes,
It is reduced.
yes, it is reduced.
But then come to 257.
257.
What is the assessment year for 2012-13?
Yes.
It is 9,25,091. Well, it got it?
Yes.
257. Then 13-14 at page 260. It is 69,850.
In your letter, you have said more than 90 lakhs. You come to page 253, that is the profit and loss account and balance sheet for the relevant period. There is no such reflection of any amount of 90 lakh rupees.
253 minus
253.
253.
Yes, 2.
Later?
No, no. In your letter, which you had just shown,
Uh,
you said that you had incurred a loss of 90 lakh rupees in transporting the labor and feeding them and paying.
90 lakh, 9 lakh.
Come to that letter.
9 lakh, 9.
358.
Huh?
358.
358.
Page 358.
Yes, ma'am.
358.
It's 9.
9 lakh.
Where is that?
At the 359 bottom. Second para, bottom, third line.
Thus, we have lost huge money, approximately 41 lakhs. So this 41 lakhs includes the 9 lakh rupees incurred over transportation. There, you say that we had to keep them here, brought them, we had to give them food. And then 52 lakhs you have invested for this.
That is an asset. So
Though that 52 lakhs which you have invested, that is not reflected in your profit and loss account. That excavator X200, either you have purchased or you have not purchased. It is to be found from the profit and loss account which you have annexed at page 253. We don't find that.
My lord is right. Whatever documents are provided to me, I've placed it.
So it's
Very fair submission I should make.
It is inconsistent, yes.
Then, my lord, I have to draw my lord attention to next This continued up to 2015, madam.
No, this didn't. Can't be.
Page 260, madam. Kindly come to page 260.
Page
260. It is 2013, 14 assessment year. Because he did not take any other works. Whatever some ongoing work and I'll say as a crusher business that was running.
that is also not borne from your profit and loss account. You have annexed the profit and loss account. It appears you have been transacting business. The
There are-
profit may be low, but you have been transacting this.
No, transaction was there.
Construction work, even in on 31st March 2011, see at page 256, construction work.
Yes.
So you have been carrying
I
on.
mentioned that there are some pending works were there. They are going on, madam.
Correct.
That I have stated that there are some pending works which are under construction. I mean, under before completion at the stage of that. I'm not denying, madam. I've already stated. Please come to page 263. I mean, 260 first.
260 you have just shown.
Then 263, madam.
Yes.
Well, then 266. Assessment there. Here it is 16,80,870. Then I want to draw my lord's attention to page 477 to 478.
278.
Before that, I just want to draw my lord's attention to 482 to 488. So the 34 application before the district judge. Before the district judge, this is the 34 application.
What page did you say?
It starts from page 482. The grounds may kindly be looked into. Ground starts from page 485.
Yes.
Para 13, the grounds are there.
Yes. Loss of profit, some amount has been quantified.
My humble submission is whether any of these grounds comes under clause 34, section 34, 32A. Whether any of these grounds, this is one of my submissions.
What is your submission?
Right?
What is your submission? None of these grounds come under.
None of those grounds come under section 34,
Yes.
2A.
Yes, you were referring to some clause 13.
Clause 13.
Now, if this is over, we will go to clause 13.
This is in the same agreement, it is there.
Yes.
Clause 13 means they will, if they abandon, they will pay me damages. That clause they did not exercise. I'm drawing my lord's attention to page 85. Page 85. It says foreclosure of contract due to abandonment of reduction in scope of work.
Page, can you?
Page 85. Not legible, but there are many provisions are there.
So should we consider it or should we not consider it?
It is not under 13, it is under 3A.
No, but you are saying it ought to have been under 13.
It ought to have been under 13 means they would have given me compensation also. The dark portion it is
We don't know.
reasonable. This is Roman 4.
We don't know, and you can't say that it is not legible, still you consider it.
They have provided the document.
You are relying on it, you could have given a one-page typed copy. This is very difficult. We have been grappling with this for 3 days now. Either paging is incorrect or it is not legible. You are relying on it. You know you will rely on it. Still, you have not given a typed copy. How can we read? You can't read yourself.
Here, Roman 4 says reasonable compensation for T&P tools and plants from site of contractor, present store. Reasonable compensation for repatriation of contractors, site staff and if any materials are there, the government will take up. Any expenditure inquired in preliminary site work, temporary assets, storage accommodation, so contractors shall be paid at contract rates, full amount for works executed. In addition, a reasonable amount as specified by the engineer in charge for their erection, which could not be utilized on the work to the full extent in view of the.
So for your submission, the first 2 paragraphs are relevant. Beyond, below that, it is only the various items.
So they had option, but they did not go for that. They have illegally foreclosed this under clause 3A. Then
And for invoking 3A, there was a time also
yes,
stipulated.
1/8 period.
1/8 period.
9 months. It was 9 months. 1/8 period. Or to be in 1 month, some days. Even arguments say that even within 9 months, they would have foreclosed it within 9 months. The claimant would not have sought for any claim because they will be returning the PG and EMD. But here they have prolonged it for 4 years, 3 months, 3 days. In 2015, my lord. Then I have to draw my lord's attention to page 477 to 478. Why the learned arbitrator has given his reason for the award. And learned arbitrator has considered that 15% which is prescribed in Schedule F, which I have shown. And he has gone, all these documents which I have placed, these are there on record. Page 477, respect to claim 6. That is the only claim is under challenge before the learned district judge and before this court.
That is the only claim under challenge.
Clause 6. Clause 6 was
The other is not under charge.
No, no other claim.
So this is the only contest, point of contest. Whether he was entitled to any damages or not. So when loss of profit has not been awarded, how damages could be awarded? This is your case.
May I read, madam?
You may.
Claimant case is that due to non-execution of this work, claimant suffered loss of profit of at the rate of 15% of the contract value, and the claimant is claiming loss of profit as damages. The claimant has also claimed that if work could have been completed as per the scheduled date of completion, in such circumstances, it would have earned profit by such date, and hence his claim interest on such expected profit from 1911 to 23/3/15. I have considered the pleadings and submission of both the parties. In the statement of defense, the respondent has countered the claim on various grounds. It is submitted that as per Schedule F of the contract, the claimant is entitled for 15% of profit plus overhead, which distribute 7.5% for contractor profits and 7.5% for overhead expenditure. This is the respondent's contention, madam. He has recorded. But the gain of profit 7.5% on contract accrues on full investment of capital cost on work by the claimant and on execution of work. Profit earning depends on management and execution to gain such profit. In the present case, the claimant never started the work on the pretext or plea of dispute at site due to objection from the forest department and cultivators. Even though the respondent reasonably believed that work could have been started. Therefore, absolutely there was no constraint to utilize,
No requirement.
no requirement for capital investment. When there is no capital investment in the work, there was no constraint to utilize the said capital without for investment on other venture. This is respondent's submission to he has recorded. Capital investment on money instrument also carry more than 7.5% interest, which would be more than contractor's profit being earned by execution of work. Hence, there is no loss on account of non-investment in this work. In the written note of argument, the respondent, however, has questioned on how the percentage has been worked out in the claim statement. Is nowhere mentioned by the claimant. The respondent has also argued that claimant has not proved breach of contract by the respondent. It is argued the basis of loss of profit is also absent from the statement of claim. The claimant allegedly contradicts in his statement of claim regarding non-handing over of site and simultaneously making investment for purchase of materials, etc. The contention of the claimant as per respondent that due to the breach of contract committed by the respondent, he could not complete the work, and had the respondent not committed any breach of contract, the claimant would have completed the work within the time prescribed in the contract. Is totally hypothetical. The reason for not doing the work in terms of contract by the claimant is the objection raised by the forest department and cultivator. The reason has to link with the respondent, and no attempt was made by the claimant to start the work. These are the respondent's contention before the arbitrator. I have considered the above submission. I have already decided that the respondent was in breach of contract. It is also found that under clause 3A was not in order. Hence, principle of law is that if a contract cannot perform due to breach committed by a party, the other innocent party should be placed as far as possible as money can do in the position that he would have been if the contract would have been performed. Hence, a party having committed the breach cannot question the innocent party's claim for expected profit. In an engineering contract, profit is normal. I do not find any merit in the pleading of the respondent that since the claimant did not invest any capital, the same money was available for investment in other ventures or for earning profit. The respondent was in breach of contract. The claimant was entitled to perform the contract and earn legitimate profit in this work. There is also no strength in the pleading that uninvested money could have earned bank interest as the instrument which carry more than 7.5 interest, 7.5% interest. In such case, nobody would undertake any engineering contract if more profit can be earned by simply investing in the instruments. It is not for the claimant to prove how it could have invested at the instance of the claimant. Instead, instance of the claimant to extricate the respondent from liability from breach of contract. Though in the written argument, the respondent questioned the logic claiming 15% profit. In the pleading, it relies on 15% as provided in Schedule F of contract and also distributes out to 15% to 7.5% on profit. Since the work could not be performed, the claimant is entitled to loss of profit under Section 73 of Indian Contract Act as naturally arising. I consider the basic cost of 85% of the contract amount. I would have said contract value is 6 crore 18 lakh.
Yes,
And
5 crore
85%
22,
of the amount is
5 crore 22 something.
to something on which the claimant would have earned profit. Considering the facts of the case and that investment of resources were hardly there, I consider 5% of as a reasonable profit that should be allowed to the contractor. My humble submission is, my lord, the arbitrator has taken the possible and plausible view. That is my submission.
And on EMD, there is no interest awarded.
EMD is interested.
Awarded. No, that you are not disputing.
Since it is a breach of contract and then as per the agreement provision only he is awarded, not the 7.5%, he is allowed 5%. And that is,
How do you say it is as per the agreement?
as per the agreement, the profit overhead and profit is 15% already prescribed in Schedule F.
So 15.
That is being considered while submitting
Not
the
as-
tender also, it is considered. While accepting also, they have considered. My humble submission is
So
the
1/3 of the expected profit as per the agreement has been awarded. Without even executing the agreement. So the arbitrator has found that even if there is no evidence, this is the amount of loss of profit which is reasonable based on the profit percentage granted in the agreement itself.
And I have placed those income tax return or those documents are placed.
That has not been considered. That the arbitrator has not taken in.
I leave it to your lordship.
No, that is all right, but the factual position does not change. The award is based on the profit margin and the fact that they, according to the arbitrator, they have committed breach. According to the arbitrator, 3A was wrongly invoked. Both these findings are there. Based on such finding, he says that
Reasonable compensation.
reasonable compensation in the opinion of the arbitrator instead of 15% would be 5%. So which are, what is the, which, under which provision you are selling the finding? It has to be circumscribed by the scope of the act and the provisions. There is no basis. Yes, you had given a judgment. What is that judgment? Yes, give that. Ah, 1960. Para 38 to 41. Hmm.
Yes, please. The 479 clause number 7. The reasons will be considered, but the arbitrator has very specifically concluded. Consider the events of the respondent, what is found is that the work could not be started except the initial attempt for filing. As discussed earlier, respondents rightly pointed out there was no fraud or compliance with procedure regarding filing works. Meaning comes from guidelines, similarly, there is no mobilization of tools. Also, there is no presence of transaction of negotiate required early resolution or don't happen. I do not find any reason for able to hire a further resource on these for this work under these circumstances. Also, there is no conclusive evidence of utilization of resource block for this particular work.
That is why, that is why you said, that is why you said if damages could not be quantified, how they have. Contract act.
The loss of damage arising from nature means it's the sisters of the mechanism. Being controls falls by the unprotected power, which must be taken into account. But the arbitrators, he said, 3 years not applicable, 3 years not applicable. Then expect other what circumstances the 3 years will remove that. Not principle.
You're also relying on some judgment.
Right?
You are relying on some judgment, no?
That percentage part, Mumbai High Court in 2017, it's considered and in para 17. I'm just pressing. Para 17. Mumbai High Court, double bench judgment. That is a division bench. Division bench. And Supreme Court judgment, this Constitution bench judgment, para 11.
Rising out of this very case. Rising out of the Mumbai High Court case.
Why not?
Is arising out of this very case. This is Supreme Court judgment.
No. This is different. This is 84 judgment. Para 11.
Other judgment of the Bombay High Court. You are referring to.
Para 17.
That's your case.
Para 17 only, that how the percentage can be relied upon, that is.
Here it was by consent of the party. Respondents conceded to 10%. But only 3% will continue.
No.
Therefore, the court is inclined to accept the percentage as elected by the respondent. Not a decision on the issue.
No. And madam, the permits, I'll.
Paragraph 17.
That's why the last paragraph. That is, I think,
Page 8 of the Bombay High Court judgment.
page 8, my lord.
Also there is paragraph 17.
Something.
The top, there is a paragraph 17 at page 11 also. So you are referring to paragraph 17 at page 11.
Page 11.
There are two paragraphs of the same. For this 17 in paragraphs, page 11 is a quotation
Yes.
from some other judge.
Yes.
Quotation from some other judge. How can there be two paragraphs? So page 11 is a quotation from the word.
Yes. Yes, ma'am.
Starts at page 9.
Yes, ma'am.
So that has not been interfered with.
But
You've seen the judgments. Don't want to see. You are.
I would.
You are there to assist the court, you're not saying anything. It's not you. You would have asked for it.
Page 11. Para 17. Malad, may I place to one more citation?
Yes.
Para 3 onwards.
When it is agreed,
Hmm?
here when it is agreed,
Hmm.
1,87,500 was 15% of the total contract amount. Therefore, it was agreed by both the parties. And here the guns were manufactured.
My humble submission is that percentage, on the basis of the percentage, the learned arbitrator, while considering the pleadings of the parties, all correspondences with the parties, and after going through all evidence, then only arbitrator has come to a finding that this is the basis I shall give reasonable compensation, since it's a breach of contract.
It says that there is a chance to the contract can be extended also, but even though the party have decided.
Bombay High Court, page 11C, paragraph 17. The award has been quoted. Paragraph 17, the respondent has conceded to tenants.
They not the reason for such termination has to be taken into consideration, not because, but this is, it says in that. If it is been cancelled and not been recorded, then a breach of contract, not for termination, then compensation is.
You are only challenging the quantum. Yes. You have not challenged anything else. The quantum there in para 17, you are missing. Respondent has conceded 10%, then only 10% has been done.
Is agreement have made a contract, that wasn't really contract.
There is a concession recorded in paragraph 7. You are not getting it at page 11. Mr. Some. Mr. or somebody's name is not part. Asurkas.
Conceded to 10%.
Yes, it is on a concession that will not constitute a precedent. When passed on concession will not. One decided.
If item number 35, Lordship. The public prosecutor is appearing for the state, Lordship. That may be taken up in the next circuit bench. Obliged.
So item number 6 and 7 is two amongst the three matters. One is before the court number 2, where the substantial hearing have commenced. I will be seeking for delisting these two matters, 6 and 7, is for the administration. But normally their administration, Babita Das appears. Come
Item number on
CO 51/24.
Corresponding method.
I'm with you. I'm with you. I'm with you. I'm with you.
Item number 2. WPS 720 of 124.
Stand for the respondent in this matter.
This is the case in Lordship relating to pension, the interest upon the pension, retiral benefit, not pension retiral benefit. By way of provisional pension, he got the full pension, Your Lordship. Monthly pension, he got full. But relating to leave encashment, gratuity, GPF, those things were withheld by the authorities. And that amount was released only after 11 months. Order in view. Page number 44.
So the due under these heads were about 36 lakhs,
Your Lordship, 35 lakhs 95,000.
about 36 lakhs.
Yes.
What is the date of charge memo? In the disciplinary proceedings? At page 46, top paragraph. The secretary has said, in view of above information, vigilance clearance was withheld. And due to pendency of the disciplinary proceedings, so the proceeding was pending.
Pending the disciplinary proceeding, and there were 2 complaint cases were.
So it was pending, that means there must have been a charge memo.
Minor.
So what is the date of the charge memo?
No discipline.
When does the disciplinary proceeding become pending, sir? What is the date of initiation of proceedings? What is the law in this regard?
But the ordinary law, my lord, the date, my lord, I will ascertain from the day that I can say, but the law ordinarily is that when there is a complaint case or vigilance clearance is required for providing the total, all the pension and pensionary benefits. If that vigilance clearance awaited in that interaction, my lord, the provisional pension are usually, my lord, being paid.
that is been paid to this person. my
All
lord, the
right, provisional pension is not in dispute. You are making a submission with respect to an issue which is not in dispute.
Not in this.
What is in dispute is that if you say that there is some vigilance clearance pending, is there any provision in the rule authorizing you to withhold any of the
My lord,
Retiral
that rule
due.
is there in CCS, CCS.
Let us see, place it. Place the rule. You are relying on which rule?
The CCS, CCS pension, I don't have the book, my lord, right now, my lord.
Then how will you assess the court?
Because, my lord, on last hearing, my lord, came from the bench, my lord, that your lordship has put a question how this matter is maintainable. Because this includes the interest, my lord, interest part, how much interest has to be paid, that's.
So now the
Why-
court cannot travel beyond that query.
No, that is.
What kind of submission you are making?
that is
The
not
court is
my-
making a question and you are saying that last time you had asked this, so I will not answer
No,
anything
no,
else.
no, but that is not, my lord, I am submitting.
Unique submission. It is your secretary's order which says proceeding is pending.
My lord.
So the court is asking you what is the date of depend. How do you say that the proceeding is pending? When does the proceeding become pending? What is the law? For law, you need anything instruction.
No,
What is the law? When does the proceeding become pending? You have not seen the decision of the Supreme Court, Union of India versus KV Janki Raman. What is the date of initiation of proceeding? You don't know.
my initiation of proceeding, my lord, they are not, the papers are not there right now, my lord. We will have to find-
Papers are on a question of law. I am asking you. When does a departmental proceeding become pending? When can you say a proceeding has been initiated in law? Forget about the date. What constitutes initiation of a proceeding, disciplinary proceeding? You're saying last time I asked this, so now I will not answer anything. Very unique submission.
No, that, my lord, I'm sorry, that I. The earlier order might have recorded.
See, you come to page 46, Mr. Chakravarti. The top paragraph, your secretary says that pendency of disciplinary proceeding due to pendency. So
Yes.
if a proceeding is pending, then it must have been initiated. What is the date of initiation of proceeding?
Show cause notice, my lord, is that.
Show cause is not initiation of proceeding. The law is very well settled.
My lord, those papers are not, appear not to have been.
The
annexed.
date of submission of charge memo is the date of initiation of proceeding. Law is well settled
Yes,
from KV Janki Raman's case.
yes. My lord, we'll just come back with those details, my lord. Those documents are not annexed, my lord.
If another aspect is you say due to pendency of vigilance clearance. So which provision in the rule authorizes the authority to withhold any retiral dues pending vigilance clearance? If so, for how long?
My lord.
For your vigilance clearance to take 10 years, the retiring person should wait. Or there is some rule regulating this waiting period or enabling you to wait altogether. Where is that? There's only two things have to be seen.
My lord, those documents are not annexed, my lord. We will. Not there. The earlier round, they were there, my lord. We'll come back, my lord. Not today, tomorrow we'll come back.
Already. As paid. The court has put a specific query to the senior counsel.
Item number 3, WPS 7/20/24.
Service has been affected, and 5 minutes. Affected.
What is the writ petition for?
Prayer is for reputation on the basis of the decree passed by the civil judge senior division civil court.
Where is the decree?
We have come to answer P5. Page number 29.
You are the decree holder
Yes, Your Honor.
or you are an heir of the decree holder? You are legal heir or the decree?
Legally, Your Honor.
When did you apply for mutation? Who is for the respondent? You are for this one. What is the
I
date?
applied on
I
25
received a copy of
2013.
writ application, my lord, if you can supply me with the writ application so that I can.
Give a copy.
Yes, I.
His only grievance is that there is some decree in respect of the land which he wants mutated.
My lord.
I don't know from when the application is pending.
I applied on 25 to 2013.
13.
Two tenants are, no, my lord. On the basis of. the
After
decree.
11 years. For 11
After
years,
that, the revenue case have been initiated and directed the Circle Patwari to supply the report.
It's a
And
presentation
report have
of,
been submitted by the Patwari, concerned Patwari. And after that, my representation have been stopped and no further action will be taken by the concerned president. Respondent number 2.
by written order,
There is a written order by the president.
stopping the further proceeding.
No initial, no.
No, after submission of report, you said that the proceeding has been
Came to
stopped.
page number 41, annexed P6,
in the application, my lord, when revenue case was initiated, that is at page number
41.
51. This is the revenue order sheet
And
and the report is
Report
also
of-
there, my lord.
So when you said that it has been stopped, who has stopped it?
after that, report have been come to the Tahsildar Fragan. After that, no.
Oh,
further
no action has been taken,
taken.
okay. So therefore, the court is trying to ascertain. Give a copy, let her find out,
Yes, Your Honor.
let the Learned Council find out
My-
what is the status. Maybe, yes, as played by Learned
Because
Council.
it's
Item number 6, sorry, item number 4, CO 61 of 2024.
Lord, I am appearing for 1 and 2, opposite party.
Your Lordship, this is that case that where preliminary decree was passed, Your Lordship, and for final decree, I filed applications. At that time, it was found that the entire records are missing. I submitted the certified copy of the entire records. The court thereafter kept on asking for the district courtroom, record room to provide the documents, and it has been there since 2021. For last 3-4 years, this thing only is going on. And your Lordship has asked me what happened on 11/11/2024. 11/11/24, this order was passed. I have obtained the certified copy.
You're for the private respondent.
1 and 2, there are 3. I am appearing for 1 and 2.
Thank
19-12 तो हो गया उसके बाद तो ब्रेक है नेट में आता नहीं
ये ऑर्डर मुझे केस का नहीं पुराना केस है
I think possibly the record may be available in High Court office because second appeal was filed, whether record was sent back or not, that is to be ascertained.
Which second appeal? You have the number.
Hey, my learned friend only
Why
filed.
don't you find out? If it is there, then the issue can be immediately resolved.
Yes, I think so, my lord.
Maybe, maybe not. We'll see what has to be done.
They tried, your Lordship.
No, in the second appeal, just
Yes,
find
second
out.
appeal only because office is same here only in the same building. So these people, the record room persons, they have gone to the High Court to search the file. There also file is not there.
The record is called for.
But even then, I will also
The
try
trial court
personally.
records were requisitioned in the second appeal.
Yes, yes,
Yes.
paper book was filed.
Paper book was filed.
So
It
it
was
has,
there.
whether that second appeal has been disposed of.
Yes,
Long back.
long back disposed of.
And this record missing is since when?
My lord, may submit subject to acceptance. A report may be asked from the registry.
The High Court registry.
Yes, because
Why?
the second, at the time of admitting this, after admission of the second appeal, LCR was called for preparation of
There
paper.
is nothing on record to show that.
Actually,
It is
record-
only requisitions are being made to the in charge district record room. You give it every time he says, I need more time. I can't find it. I need more time. So this has been going on for how long?
3 years, your Lordship. 3 years it's going on like this.
And the court, unfortunately, the court is saying, let copy be served on the in charge district. He is the one who is giving the report. What is the point in serving a copy upon him? He works under which authority?
District judge.
Huh?
District judge.
Restriction.
The report can be asked from both the registrar and the district judge.
Initially, it was the civil clerk who was required to find it.
Yes, your Lordship.
Then, since when the district in charge has been directed? How long has he been directed? Civil clerk is up to April 24. Civil clerk.
Order number 21, 3010, page 75.
That is the only impediment.
Your Lordship. I am seeking that it may be reconstructed and thereafter the case may be proceeded. I have been asking the court for that purpose. Because I have all
You
the
know
certified
that the
copies.
record is not available anywhere.
Your Lordship, this type of report is only coming. They are simply asking time. Even we have personally also, I requested.
What is the, can you give the second appeal number?
Yes, Your Lordship, I can provide. I am giving.
And its state of disposal, do you have both or you don't? But 3010 says that the original records were dispatched to the record room on 26/2018.
Yes, Your Lordship, that is the.
So the second appeal has been disposed of prior to that.
Right.
Then second appeal is meaningless because the original record was already there.
The record, possibly they.
Reference to second appeal now has no relevance. It's not very old also. It has been sent to the record room in June 18 itself.
18, yes, Your Lordship.
Not very old.
There is a direction upon the Ghana district judgment. Place a report before this court. That will serve the purpose, in my opinion.
Now you have the 1111, but what happened on 1912?
Same order. Your Lordship.
Same order.
Same order. Same order was passed. Mhm.
And what is the next date fixed?
24th January.
So how can it be reconstructed?
Your Lordship, requisition has to be made to the High Court. By the, as per civil rules and orders, the learned trial court has to make a requisition to the Honorable High Court. And thereafter direction will be given to the registrar for reconstruction of the file.
No, that is the official process.
You know,
Where are the documents based on which it can be reconstructed?
certified copies, I have given it to the learned court.
Oh, it
It's
is there.
It's there. All certified copy I have obtained.
All right. No, but the responsibility for the records being lost has to be borne by someone.
Someone has to be, yes.
This
held
cannot be,
responsible.
yes. Had it been a record of antiquity, then it different things. A 2018 record is missing, very unique. Keeping it on Monday.
Yes.
This is which serial? This is
Item number 5. WPA 5 of 125.
The respondents.
Lordship, I paid for next second as the service not affected to the private respondent.
How many private respondents?
Only one. I served the copy, but
Petitioner as a private respondent that the system is not.
the private respondent left for mainland, Your Honor. And I came to know that he came back to this island on the end of this month. I again served this copy and
So application for demarcation
yes,
has not been done.
no.
No, that they have, according to him, they have aborted that entire process to be done by an ETS machine now. So why it is to be kept pending? We will proceed with the demarcation after due intimation and notice to the concerned parties. Not, need not be kept pending. Can be disposed of right now. The
Item number 6.
No, I have any time bound.
how much time would be reasonable? 4 weeks. Yeah, preferably within a period of 6 weeks from date.
Highly about.
Item number 6, WPA 10 of 2025.
6 and 7, as I've been saying, my lordship, the third matter is before the court number 2 when a substantial hearing have commenced.
Oh.
Let this matter, two matters be delisted with the liberty to mention before the court number 2. 6 and 7.
They are connected matters.
Yes.
These are connected matters. The matter is being taken up in the court number 2.
I'll try. Okay. बटन की था इनमें तो सिंपली सेट ऑफ नंबर्स ऑल फैक्ट्स आर
These are all individual notices. This cannot be connected.
no one and same law. The two sisters, one brother are 3 read petitioner and 3 read because they have their independent right for the land in question.
That's exactly what the court is observing. It's an independent right. So why are you challenging a notice?
No, the thing is, first of all, the show cause notice has been issued by an authority who is not vested with the jurisdiction. I brought the judgment of Supreme Court. Even at that juncture, it can be questioned because I am not supposed to take the full course of the proceeding. If I could show that ex facie the proceeding is bad in law, that's first point.
Let us see.
My lord,
That is the only issue to be.
my lord, my lord, my lord would see page.
According to you, the eviction officer under the Airports Authority of India has no jurisdiction.
Yes, my lord.
Let us see.
Finally turns to page 31.
Yes.
Because the notice pertains to survey number 66.
No, let us see the act, section 28 of the eviction of unauthorized occupants of
Public
airport
premises,
premises.
1971, yes, no. A state officer who has been duly notified under section 4, he has not been notified under the act to act as an estate officer. He simply says to be an eviction officer. Public premises eviction of unauthorized act, lordship. There is a notification published in the Gazette appointing a state officer. The same authority nominated one of his officer an eviction officer. Invoking 28C, the show cause notice has been issued. Palpably without jurisdiction, lordship.
What is 28C?
Even I could not. Section 28C. This has no relevancy and no acts, nothing. Simply it's 28C of eviction of unauthorized occupants of airport premises.
You are representing the airport authority.
The commissioner Kessel are open.
So why you have included them?
Yes, the reason behind is the land is a government revenue land right from page 31. Survey number 66, my lord would find it's not the land owned by airport authority, my lord see 50.
But your prime relief is against this authority.
No, my lord, what I'm trying to say, my lord, 31, 33 may kindly be seen, my lord. Survey number 66 is recorded as a government revenue land. If so for the sake of argument, if I'm an encroacher over the government revenue land, regulation 202 is the remedy.
So therefore, again, it is the action of this eviction officer which is impugned.
Absolutely, my lord.
So why are you there?
Because I want the regularization of the land in terms of
It
this.
can't be done here. That cannot be done here.
My lord.
Only the validity or invalidity of this notice.
Absolutely,
So
absolutely.
who is his respondent?
I'll serve the notice, my lord. Eviction officer.
You could have served on him. Let the yes, counsel for the petition.
Item number 7.
Same order, same.
Same one. You may want to examine the writ of prohibition is also a remedy under the Article 226. Yes, where authority acts without jurisdiction and you do not subject yourself to the jurisdiction of the authority. Then prohibition. Once you subject and still he proceeds, then certiorari. There are two different stages.
Great.
Yes.
I'm good. I'm good.
Item number 8. WPA 13 of 2025.
But what has happened? There are several rounds of litigation. This is for the fourth time and before this court. But in this island, as and when regularization are effected, the corollary act would be by way of issuance of a license. In the present case, it has been done since I'm occupying the subject land since prior to 1978. I'll show the license. The license is at page 27. Page 27, annexure P1.
Yes.
My lord would see clause 5 of this license. Once this license is issued, the authority is under a bounden duty to assess premium. It's nothing but a revenue in terms of the local regulation, which has to be notified to my client. When that is done, the records would be finalized. It would be maintained in the office of Tahsildar. That was not done in the present case. For the first time,
What is the date of license?
its lordship 6th of January 1989.
And since 89, no premium ascertained.
No, not this court issued a writ of mandamus. It's 32. Kindly have a look to page 32. My lord, I'm just a coordinate bench of this court. Now would see page 34, the operative portion, page 34.
No, this is this only directs to ascertain the excess amount of land held by you.
Yes, then my lord, A says, thereupon the respondent will empowered to take possession.
Correct.
See,
Nothing has been done.
See, my lord, the respondent will accept the premium.
This is a consequence of A.
My lord.
You can't jump to C directly.
My lord.
First A has to be done.
My lord.
So till now,
it's been done.
Even your encroachment has not been ascertained, let alone issuing any license.
My lord.
Where is the question of license before this?
No, license has to be given first. Lord, license is being based on an inquiry.
So where does this order of 15 June 2017 record that you have been issued a license?
Yes, my lord.
So right now, the court is only directing to ascertain your extent of possession.
Yes, my lord.
So where is the question of license will not precede such ascertainment?
The first
license can only come after this.
After I am maintaining possession.
But after this exercise taken under direction A, then only a license can be.
No. Possession, I have to show possession, then authority would hold an inquiry, then a license would be granted. Once that is done, then assessment would be done. I would be notified as regards the quantum. I would pay the money, then the records would be finalized before the Tahsildar. That's the procedure. So I'm in possession since prior to 1978, license has been granted, but in terms of clause 5, assessment has not been made. So this court in the first round has directed them to assess it. If there is an excess land, you take it. Even I am agreeable to that. That's the condition of law also. One has to surrender the excess land beyond what is there in the
Got it, yes.
My lord. Then, my lord, twice, second time also this court was approached, nothing was done. Again, third time at page 39, the orders of this court is there. Ultimately, page 40, the impugned order has been passed. Ignoring these three orders.
Page 40.
43. 43. Letter P7. The deputy commissioner says it can't be done. Those three orders attain its finality, no challenge, nothing.
Page?
Page 43 and 44 are the impugned orders passed by the deputy collector.
He says there is no license.
Not sure. This can't be done. The writ court has said twice, the second time the court has said, third time said, fourth time when the court directs, they said they take this plea. They say that my name has not been figured in the High Court. How that can be based on that?
Because earlier some court found a forgery and directed for criminal case also.
That was set aside by the division bench.
That was set aside and left to the authority to decide. So the authority has found that there is no license.
In the light of entitlement record by first order by our ladyship Justice Champa Chatterjee.
And all the later orders become redundant.
Everything has to be taken into account.
So there is a development. You can't rely on the earlier order now.
Everything has to not kindly.
Only you have come to the court twice and thrice.
My lord.
And you have got these orders.
My lord.
So the one of the proceedings, the court found a forgery.
That is under challenge, Lord. That is under challenge. That order.
Therefore, there is no question of license now.
No, Lord, license would be based on my possession, based on an inquiry being held by.
Read the order, sir. Come to the order.
Of the deputy commissioner.
No, come to the court's order. 22/11/23.
My lord, may I place it?
Yes.
Prima facie, it appears that license was granted in favor of petitioner on 6th of January 1989 by the deputy commissioner Port Blair in plot number 25/5, measuring area 0.02 hectares, situated at village Dolligan. The petitioner applied for determining and assessing the premium of the licensed land. It appears that in an earlier writ petition being WP number 226 of 2016, an order was passed by the learned single judge on 10th August 2016 by which a direction was given upon the authority concerned to consider the representation dated 28th March 2016 for acceptance of premium in respect of licensed land. The said representation was not considered. The short issue in this writ petition is with regard to the assessment of premium payable by the petitioner for the licensed land to occupy for house house. The learned counsel for the petitioner has referred to two orders passed in the earlier proceeding by coordinate benches by which authorities were directed to assess the premium amount payable for issuance of license and to take the benefit thereto. The respondent's authority did not accept the premium on the allegations that the license document has been forged and fabricated. The coordinate bench on 16 December 22 directed Tahsildar Port Blair to register a formal complaint with local police in respect of forgery and fabricating alleged against the writ petition. The said order was, however, set aside by the division bench and the matter was remanded back for consideration upon exchange of affidavit. It appears that the basis of claim for forgery is based on order passed by the revenue court in regard to respect of Brij Lal, son of Ram Amtar, in survey number 25/5 for 0.02 hectares. It was found that he was occupying government land area of 0.02 hectares bearing survey number 25/P during the year 1978. His by the High Court Committee. Under such circumstances, I direct similar exercise to be undertaken by the respondents and in the event the petitioner is able to establish that he is pre-1978 encroacher, he would be entitled to be treated similarly by the High Court Committee. Moreover, prima facie, it appears that a license was granted by the administration in favor of the writ petitioner. Under such circumstances, I dispose of the writ petition by directing Deputy Commissioner South Andaman to decide upon even reasonable opposition of hearing to the petitioner whether the petitioner is a pre-78 encroacher, and in the event the claim of the writ petitioner is established to the extent same benefit that was extended to Ram Kishan.
So now it has gone back to ascertaining whether you are an encroacher of pre-78 or not.
Yes, Lord.
So therefore, now the commissioner has passed an order, you go before the secretary by a writ petition.
But this is not under the local regulation. The order one which has been passed under the local regulation is unable to an appeal. This is not under the local regulation because license has already been granted. Had the case there been and there is no license granted, I could have understand.
Now it is not a case of license having been granted.
No, license is there.
Please read paragraph 9 of the court's order. Again.
Under such
circumstances, it is yet to be ascertained whether you are a pre-78 encroacher. Where is the question of license? Even the issue whether you are a pre-78 encroacher or not has to be seen.
But this pre-78 scheme is not acquired its legal sanctity under the regulation because appeal would lay in respect of those order.
In respect of, all right, let us see the.
Kindly have a look to regulation 28 once. Only those orders which are passed under the local regulation are amenable to an appeal. And there can't be any appeal in respect of other orders. 28, my lord.
from every original order passed under this
Yes,
regulation.
my lord, yes.
Every
Yes,
original.
under the regulation, my lord.
Yes. So what do you mean regulation?
Regulation, the present regulation, 1966 regulation.
Yes, so it is under the regulation.
No, my lord, but
Under which authority the deputy commissioner has ascertained the issue or decided the issue?
in terms of the direction of the court. In terms of the direction of the
Direction of the court is only under the provisions of the rules. It cannot be divorced the regulation.
Well, my possession needs to be ascertained.
No,
Whether
no,
we
whether-
have it even on 470 days.
Yes, that order needs to be challenged before the authority. Why the red court should interfere at this stage?
My lord,
And what is
there are-
our prayer? Where is the question of ascertaining a license fee now, a premium? The issue is totally different.
That's my case all about, my lord.
Cannot be. The order, you cannot ignore the order passed on your earlier writ petition.
Well, first order, my lord, sees her ladyship's order just.
You please see the last order. You are required to see the last, not the first order.
Taking my loss to all the three orders.
That is the development which you have caused by virtue of 3 proceedings instituted at your instance. Finally, the court has come to a conclusion that a lot has to be ascertained before you can claim ascertaining of a premium or a license. So therefore, it has to go before the authorities.
My humble submission is, since the order impugned has no color under the regulation, no appeal can be laid.
That I will consider. Yes. The petitioner. What is
Item number 9. WP 18 of 125.
Now the Tahsildar, invoking the provisions of 202 of the LRR 1966, passes an eviction order. The first ground is certain adverse materials were collected without putting me in notice. Even I have not been allowed to have an inspection of those reports. This has arrived. Secondly, for 202, my lord looks into the remedy to challenge an order passed under.
Is there any decision of the court as to the, or is there any provision as to the procedure to be adopted under 202?
Yes,
Where is that?
202 itself.
It only says summary proceeding.
And I have to approach a civil court as against the order passed under 2021. I cannot go for an appeal, my lord. 20, page 40, my lord.
Yes.
Any person who unauthorizedly takes or remain in possession of any unoccupied land or abadi may be summarily ejected by order of Tahsildar, and any crop which may standing on the land, and any building or other work which he may have constructed thereon, if not removed by him within such time as the Tahsildar may fix, shall be
It
liable to.
specifies the powers. The court asks you whether, how the power is to be exercised. What element of natural justice, show cause is required. What are the, this doesn't say anything. It says summarily ejected.
Not 5 may kindly, not, because inquiry it's a civil wrong. I have a right of audience, my lord. I have a right of audience, my lord.
I think the court is asking you, is this issue ever considered?
No,
by-
no, because
As-
no, my lord, not by any court of this island. There are orders of this court which says once 2021 order is passed, one has a right to go to a civil court in terms of 202.
Therefore,
7 and 8.
at this, you say that nothing was allowed to be seen. Therefore, the court is asking you, you can challenge it in a suit.
Well, that liberty I want, because eviction order, it's a very haste manner the order was passed.
Where is the liberty required? The very same regulation gave you
But my lordship,
the scope of doing it. You have not done it.
but in a haste manner, not kindly see when the order was passed, what is it? Cutoff date given, but kindly have a look to it.
Please, yes, which,
No, it can't be at least.
which order?
Not, it's a 21, page 21. This Tahsildar 2021.
You go before the commissioner, deputy commissioner.
So civil court is the remedy, my lord.
No, sir.
No, kindly.
It is not.
2027.
207 and 8 are, if you chose to file a suit, you could have done so. It is not a remedy against the order passed by the authorities.
But
In the last 1 week, I have also had the occasion of going through the provision. You may have made this submission on the first or second day, but not today.
Lord, may I persuade my lord with the order of this court? Actually
Yes.
on the point. 202 suit is the only remedy. I can bring those orders of tomorrow. I can bring it.
All right.
There are orders, my lordship.
As paid by land
My lord.
for the petitioner.
Item number 10. WPA 24 of 2025.
What is the relief, sir?
Petition for the execution of the order caused by the Secretary for the Municipal Council, because the private respondent,
You are the private respondent
the municipal council,
and you are for the state, and private respondent is not represented.
tomorrow I served it, but receipt has not been acknowledgement.
What is the relief?
Relief for it, 25 to page number.
Regarding some building plan?
Yes, all the building plan is accepted with.
Coordinate bench of this honorable court has delegated the matter to the appellate authority, not wherein that execution order was passed. But subsequently, they prepared writ application before the coordinate bench. And principal court, and the principal court has directed the appellate authority to dispose of the appeal.
For demolition of
It
the
is such time-
private response.
Oh,
They want an implementation of the demolition.
Demolition of the demolition. It's
It's
5/4/2021.
the order is 5/4/21.
And November 29. The final order. Madam, interim order is pension.
28. No, 27.
The demolition.
The stay order. And 28 is the order, the demolition order by the secretary.
28 is the demolition.
November 24. This order has been stayed.
I'm not aware.
Last paragraph of the order, or please understand the, let us take a. The Bombay Municipal Government refrained from.
Oh, he is the person whose demolition is to take place.
Yes,
Yes, yes.
Naveen Topo is the person. Who is the
Who is
private
suspected
owner
to-
over here.
Building.
No, but here there is some Birsa Munda.
Birsa Mumbai is a person, now he alleging that the land belongs to him. And then demolition order has been passed.
But this order has been given to the private.
Naveen
estate.
Topo, against Naveen Topo only the demolition order has been passed.
When you see the Revenge order, madam, it has been issued to Naveen Topo.
Naveen Topo order has been challenged by Birsa Mumbai and everybody.
Implement the order 29 November 27.
Already let the private respondent appear.
Tomorrow.
Yes. The counsel for the respondents are in appearance.
Number 11. Now to be a 486 24.
I am for the petitioner. Madam. I filed this writ application against the improved order passed by the Deputy Commissioner.
What has he done?
Rejected my claim, saying that wait till disposal of the SLP pending in Supreme Court.
You don't want to wait.
No, one person was granted license from the list. My name is Appeal. Kindly come to the list first, my lord.
Prior to the matter becoming, prior to the Supreme Court
Decision.
being, then how can you compare with him? You cannot.
No, extension of benefit is to be given. One person was given from the list.
One person was given prior to the stay.
No, during pendency in the Supreme Court.
Prior to the stay.
There is no stay.
There is no stay by the Supreme Court.
No.
It is only pending.
Yes.
And when it became pending.
Pending since 2002. Kindly come to page 13 first, 1-3. There is a list, madam. 89 persons are there. Now, my lord, kindly come to straight away page 40. Serial number 3. Name may be noted, my lord. Serial number 3 is Mohan Raj.
Wait, this is forest land.
The government approved for granting license to everyone.
Or reciting them.
Yes.
For granting license or reciting them, relocating them.
No, from their respective possession. This one was already taken.
In the forest itself.
Yes. Kindly come to the list, page number 13 first.
Yes.
Serial number 3 may be seen, Mohan Raj.
My name is appearing at serial number 4. Now kindly come to page 40. 40.
Which is the impugned order?
Page 27.
So what is pending before this? No, pending means what is pending? The Supreme Court has No, it's not pending. It was taken up by the Central Empowered Committee. In 2006, the CEC has passed an order that either you give alternative land or you take clearance from the forest department, but do something. Because they have been found as being encroachers prior to declaration of the area under Section 2 of the Forest Act as a forest land. So therefore, it is to be done by you. That pendency is not coming in the way.
One person was granted, page 40 may be seen.
Another list.
No, no, no.
No, 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 no. He is from the 89%.
Page 40 may be seen.
Page 33. It was considered from this list, which was not put by the DSO.
33.
Page 36.
Yes.
35, his name appears at serial number 88.
That is the alternative land which has been given to him. So that therefore he is also, that's why I asked him, he's saying no, regularization of this land cannot be. The CEC has said either to give a land under the revenue area or to take appropriate clearance from the forest department. So it cannot be regularized like that. That is a settled issue now.
First, then kindly come to page 40. ROR is there. The remarks column will be seen.
Page 40.
Well, this is license. ROR granted to Mohan Raj. Remarks column will be seen. I am reading. In pursuance of Honorable Supreme Court's order dated 7/5/2002, pre-1978 forest encroaches regularized and rehabilitated by file number so and so, so and so. So based on that order, license was issued to Mohan Raj.
What is this?
This is ROR.
Can't even read it. In pursuance to Honorable Supreme Court. Where is the order 7/5/2002? Show it.
That order I don't have.
You must show it. You yourself have gone to the Central Import Committee in 2006 and now you are relying upon a document of 2002.
My case was recommended. They are not disputing that.
What did you get in by the Central Import Committee in 2006?
That was recommended.
Where is that? Show that.
It is there in the affidavit.
Show it.
Come to page 5. Affidavit filed by book.
Can you rely on 2002 document when after that you have already gone to the CEC? What is the order passed by the CEC?
CSC order is not there.
So none of that is there. You are just waving one document on the.
Admitted fact by them in the affidavit.
Show the document, sir. Come bona fide. Come bona fide. Therefore, the court is saying, it is your case. You are an encroacher which was declared as a forest land.
Yes.
Matter was brought to the notice of the Apex Court. Apex Court referred the matter to the CEC. CEC looked into the matter, framed a particular modus which can be done.
Yes.
Which can be done. Recognizing that you are a pre-78 encroacher, but now it lands fall in the forest, therefore you cannot regularize there. This issue is settled. In 2006, the CEC has passed an order in your favor. You have not got that. You are relying upon a decision of the Supreme Court 2002. You have not got that. You get it. Then if you want it to be resolved, you have to show those things. Otherwise, it cannot be done. The
What is it? Sixth line. The said report has been registered as IA number so and so by the Honorable Supreme Court. The said report, the CEC broadly divided the encroachers into 7 categories. on such category is the list of 18.
This is precisely what I was just observing.
Right.
Matter was referred to the CEC. CEC has said either in situ or ex situ. In situ cannot be done without forest clearance. You know that. Only ex situ can be done by them without forest clearance.
But one person was was granted.
He was granted ex situ. He has been granted agricultural land. He has not been granted in situ. It's clear, sir. By now, I have also seen, therefore I am asking you. And you are not showing these orders. How can you cannot be regularized in forest? Impossible. Cannot be done.
Case was,
Show that he has been regularized in the forest area. Show it.
his name is there in the list.
Sir, there are two things. One is his name as an encroacher in the forest area.
Yes.
Other is his regularization.
Yes.
Show that his regularization is in the same forest area where he was an encroacher.
Possession, that same land was regularized.
No, it has just been shown that it is agricultural land.
Page 13 may be seen, the list, 89 list.
We are not concerned with 89 list. Where is the regularization order?
It is there.
Show that it is, where have you stated in the writ petition that he has been regularized in the forest area? Show that pleading. Show that statement.
That statement is not there.
Don't make such statement.
License
That
was given,
whatever has not been stated by your client, don't say it.
but license was given.
Whatever has not been stated by your client, don't say it. Because then it becomes an incorrect statement.
No, madam,
Don't say it.
license was.
Please show that statement. Any evidence which you want to show will only be in support of the averments.
Yes.
So if the averment is not there, the court is not going to look into it. You know that. Therefore, the court is asking you show when you have said that he has been settled in a forest area and regularized.
That
Please show from the writ petition. You can keep on submitting the same thing 10 times. If that case is not made out in the writ petition, it can be rejected right now.
kindly appreciate.
No, that is what I'm trying to do. I'm trying to appreciate. That is what I'm trying to appreciate. Where is your case? Now let us see.
Should be dismissed. They say that.
Now let us see.
Disposal of this
Now,
consent.
so you say no, I want it right now because it has been given. No, show from the writ petition. Where?
So
Show from the writ petition where have you said that in the forest area, the person has been regularized. Show.
kindly see page number 13.
All right.
Page number 13 is the list.
That is not the list of regularized persons, sir.
Yes, statement showing the particulars of pre-1978 encroach identify the committee out of.
You very well know what you are saying. You very well know what you are saying.
From the list. I'm
You
saying,
very well know what you are saying,
This
sir.
89,
That list is not in dispute by them.
this 89,
That list is not in dispute by them. And that list has nothing to do today with your claim. Why are you taking it back? In 2006, where is the order passed in your favor by the CEC? And where is the order of 2002 that you are relying on? Show that.
tomorrow.
Bring it. You cannot get a regularization in the forest land like this. Cannot be. And that person has not been granted in the forest land. He was an encroacher like you in the forest land, not in the forest land, in the lands which was subsequently declared as forest.
Then I should be allotted then alternative land.
Now you are coming to the correct submission. Now you are coming to the correct
Because
submission.
their prayer kindly see the.
Now whether that is to be done.
My writ application should be dismissed. They say that wait till disposal of the Supreme Court.
Correct. So therefore, whether you are to get an ex situ or in situ has to be considered. It is not so simple that he has been given in forest, therefore you should be given in forest. So now I can call upon them. Why are you not giving him his similar treatment like the other person? What comes in the way? What is your decision? Where is your stand taken in the? How do you distinguish his case from the Mr. Mohan Raj? What is his name? How do you distinguish his case with Mr. Mohan? No. His case is not considered from. His case is considered from 89 encroachers. 89 out of 1278 or something like that. Where is that?
Serial number 38.
What is this document? This document is not list. No, how this list can be read like this? There must be a letter covering this list. This, what is this list? List is prepared for what? What is this list prepared for? You are all relying on such lists, one list, another list.
This was prepared by the Divisional Forest Officer in the year 2006.
Yes, this must be pursuant to the CEC's direction. That is precisely what the court has been saying. This is pursuant to the CEC's direction. So they have identified that these are the encroachers lying in the forest area. They are all pre-78, including the petitioner. That is not in dispute. So therefore, he is similarly situated. Now they have, the other person has been allotted some land in revenue area. That is his case. Have you denied this aspect? What have you said about Mohan Raj? Let us see, where have you said? What is your claim?
Page 5, para 11. Entitlement to get license, whereas in the case of Sri Mohan Raj, son of Sri Jagannathan, cannot be considered as listed. Sri Mohan Raj is a 378 forest enclosure, and his name appears as serial number 88 of the list of 129 378 enclosures in South Andaman district. And he was granted license to occupy agriculture land measuring an area 0.93 acres situated at Kodiyaka by license dated 24/8.
Oh, he was issued license in 2002,
Yes.
much before the CEC's constitution.
This below. This 89 encroachers below, which is pending before the Honorable Supreme Court.
Written in this document, Mohan Raj name is there.
They will not get from that list if he is getting from this list.
Maybe he's having other land also, I don't know, maybe.
He was the list of 129 encroachers. Not the 89 encroachers list.
Can't be, because 89 encroachers have been considered by that 2006 order is not, why didn't you bring the 2006 order? He has given a reference to 2006 order that will determine his status. Whatever is decided by the CEC, that will have to be complied, because the CEC's orders are under the
Supreme Court direction.
And all the records.
CEC records. You want to resolve the issue and plead them as a party. Plead them, because CEC must be relying on all the documents from the forest department. Cannot be by the revenue authority.
When I made subdivisional officer South Andaman as one of the party responsible.
How he will represent the forest department? It has to be DFO. It has to be DFO, or I don't know any higher for a forest authority, conservator, chief conservator.
Principal Chief Conservator of Forest is there.
PCF,
PCCF,
PCCF. What is the designation? Can you tell?
Principal Chief Conservator of Forest. Andaman Nicobar.
Andaman Nicobar, PCCF. In view of the controversy arising in the present Yes, next. Many matters. Also, we'll come back, we'll sit for half an hour.
Item number 12. WPA 320 of 2024.
My lord, in this matter, senior advocate Mrs. Mark is appearing on behalf of the petitioner, my lord. I pray for just not today, my lord. Much attention.
Item number 13. WPA 709 of 2024. Item number 14. CRR 26 of 2024.
Your Lordship, item number 14, 15, and 16 are connected matters, Lordship, wherein an order of family court is under challenge before this honorable court.
Why a state party?
States, because it is the order of the family court, state and the husband needs to be a party.
WPA 428 of 2024.
Give the file. Not today.
Item number 18. WPA 525 of 2024.
Yes, not today.
Item number 19. WPA 235 of 2025.
Lordship, I am for the petitioner reading, Lordship. This and
For grant of electricity.
yes,
connection.
Lordship, yes, Lordship.
You have not served a copy.
So, Lordship, I have served a copy to the learned counsel who is appearing for the electricity department, but I could not serve the copy to the department.
No, he was accepting the copies yesterday.
Yes, and I have already served, Lordship.
So your claim has been rejected.
Lordship, it comprises of electricity connection of Hudbay. There it's offline, Lordship. So there is no provision for rejection. I have filed the application on 19/11/2024 From then it is pending till date. In online, we can file and after a month, there is a rejection, but in offline, there is nothing like that. It's pending, lordship.
So if a month has lapsed, is it to be deemed that it is rejected?
In online, it is like that only, lordship. But in offline, where there is offline procedure, after a month, we come before this honorable.
So what according to you, you are having the,
Lordship, I'm an encroacher, a settled position, lordship. 2005 2500 square meter. I'm encroaching. I'm living with my family. Since 1999, I'm encroaching there. Before that, my father was encroaching the same. Now he has died. I'm in that, lordship. Just electricity, lordship. It will not confer any right to me, lordship.
no, there are two things required to be given. One is an indemnity.
Already given, lordship. I have given the undertaking affidavit and the declaration, lordship. Page number, lordship, 15, 16, and 18, lordship.
And what about ID proof?
Lordship, page number 14, lordship. I am the local resident of that same area, lordship. Hadway Island, lordship.
This is on the same premises.
Same premises, lordship. Kalinagar.
What is your name?
Babul Sarkar, lordship.
You read the affidavit.
Babul Sarkar, lordship.
Again, read the affidavit. Does it say I?
I, Babul Sarkar, son of late Haran Sarkar, age about 45 years.
Please show.
Clerical mistake, lordship. Leave may be granted, lordship.
You have to, there's the affidavit.
Yes, lordship.
The learned counsel for the petitioner submits that typograph.
Lordship.
Where is the application?
Lordship, page number 21, lordship.
There is no receiving given with a seal or anything.
They have given like that on their.
How can it be accepted that it was submitted? Offline, I can understand, but there must be some official receipt granted. Then you let him be here.
Yes, yeah.
Let counsel for the petitioner, the counsel for the
I'm appearing for the writ petition matter. Copy has been served upon the respondent.
Where is he? Today, none of you were appearing in person. This case also electrical connection is not.
My lord, for grant of electricity direct.
Has been rejected.
Yes, my lord. It has been rejected. Thereafter, again, application has been made by curing the defects pointed out in my first application. My lords may kindly come to page number 16.
Ask him to be here. Ask him to be here tomorrow, not today.
Oblige.
Not today.
Number 21. WPS, number 21.
Senior advocate Mrs. Nag is appearing on behalf of the respondent. I pray for a short passover, my lord.
Where is the petitioner? None appears for the.
Your Lordship. Writ petition was already disposed of. In can also order has been passed.
The petitioner is seeking benefits under the Provident Fund Act.
No, he wanted the salary because he's the contractor.
Oh.
He wanted that the salaries to the employees whom he was deploying to BSNL has to be paid. It was not paid.
Contract labor.
Yes. So he filed a writ application saying that BSNL is being the principal employer, he's not paying to the contractor. And therefore, these people are not getting the salary. So direction was given that you have to pay the salary. Now, what the contractor started doing, after receiving the entire amount, he was not making any payment to EPF. And he was distributing the salary and remaining he is keeping by himself. So I filed an application for a direction upon the contractor so that the amount can be deducted, EPF amount can be deducted and paid to the remaining amount can be paid to the contractor.
Which has been allowed.
Allowed.
Yes.
Now nothing remains. Writ petition has already been disposed of, can has already been allowed. Nothing remains in the entire case. So it is to be disposed of, that's it.
None appears on behalf of the petitioner. None appears on behalf of the petitioner.
Item number 22. WK 52 of 2020.
appears for the petitioner, just not today. Already service affected to private respondent.
There is private respondent also. You are representing.
Service already have filed affidavit of service,
Not today.
just not today.
Presence of land counsel for the respondents.
Item number 23. WPA 137 of 2020.
Lordship, I am for the petitioner. The last order may be seen, Lordship, passed by this honorable.
What is the issue?
Regarding
That-
the fruit vendors, please.
Oh,
Direction was given by
oh,
the.
yes. Yes, what is your issue?
Fruit vendors, there are no other fruit vendors except the fruit vendors that were allotted the space in Mohanpura market on instruction and submitting. No other fruit vendors were allotted the space. And these fruit vendors were having the rent, they have to pay the rent of 1,500. And since September 2011, the petitioner, the fruit vendors were paying rupees 20. In 2007,
So according to you, nobody is paying 1,000.
nobody is paying. And all the fruit vendors were given the open space only.
No, but he has shown the document where there is.
There were vegetable market. Let me kindly come to the annexure that
Yes.
order, page 25, that was shown.
Page 25
Of the writ application,
Yes,
This is the list which he was showing. That
yes,
others were charged 500, 800, 1,000 like that.
yes,
And he was charged at 50 per day. That means 1,500.
500, yes.
And the fruit, and there are others, my lord. These are the shops that were in different locations, and these are not fruit vendors. And the question is now only on the fruit vendors. And no fruit vendors were given the RCC with shutters and all. Observe in the last one. My lord has observed that they were provided with, other fruit vendors were provided with the properly constructed shops. No, no.
That is a specific case.
Yes, Lordship.
Vendors were allotted as open space. They make their construction with the tarpaulin sheets and all. They were not allotted with RCC shop rooms. In fact, they are not willing to go within that RCC shop room since it's on first floor. And they have accepted this only.
Lordship, the
They have
content.
shown willingness and they have accepted that open space.
Lordship, the contention of the learned, my senior, is that if the other food vendors are not asking for parity, I should
Vendors.
not be asking the same, Lordship. The petitioner,
The court has asked
Yes, sir.
to clarify things.
Yes.
You are necessarily listening. Yes.
As on date, there are 39 fruit vendors here in the Mohanpura market. And all the fruit vendors were allotted with the open space. And even they were they were asked if they are intending to have a RCT shop rooms, but they have to be shifted to first floor. So nobody was
So
interested.
in this list at page 24,
Fine.
who is the fruit vendor?
Fruit vendors are serial number 45. Page 25, serial number 45.
Pahargaon. Paragaon.
Lordship,
Mohanpura.
No, serial 45 at page 24.
yes, 25, Lordship.
Yes.
Page 25, serial number 45. This
Yes.
is the fruit vendors.
32 fruit vendors,
And
Lordship.
others are different establishments, some slaughterhouse.
Oh,
Shopping
so this
complex,
is the only place where the fruit,
place.
so all fruit vendors, there is no disparity among the fruit
No,
vendors.
there is no disparity between the fruit vendors. All were given this open space only, and they have accepted it. They're not interested to shift to the RCC building because it's in first floor. So they're happily there. They have
I've
accepted
seen
the
on the
open
last
space.
occasion, he didn't want to go and therefore he is allowed.
Yes,
to.
This is the case. There is no disparity of rent between the fruit vendors now.
So which fruit vendor is paying less than you?
Lordship, I have never said that other food vendor is paying less. My specific, no.
Right, let him make this.
Lordship, my specific argument was that other shops which were having RCC shop, shutter and everything, serial number 20 and 22 of same area, the vegetable market, Mohanpura and the vegetable complex Mohanpura are paying rupees 1000 for a shop of 9 square meter of RCC and rolling shutter. And I am a fruit vendor who is getting 1 square meter of area in an open space, and I am taking an abnormal high rate of rent, rupees 1500 plus GST, Lordship. This was my specific question. And from 2011 to 2016, the rent was rupees 20 per day. Suddenly, within a span of less than a year, it was increased from rupees 20 to rupees 50. This was my specific case, Lordship. Before this honorable court.
This is a relief beyond the scope of Article 226.
Lordship, kindly appreciate. Lordship, kindly appreciate the fruit vendors are in parity with the same places of the Monpura vegetable market. There are 180 shops vegetable market, Lordship, 180 shops, and they are giving, they are taken rupees 1000. And I am in 1 square meter of area at an open space, I am taken rupees 1500.
You are not paid.
Lordship, also the GST is being charged from 2011 from these fruit vendors.
It is not the remedy for everything. I'm not saying all is right. But you have to choose your forum. This is not the place where a rent can be fixed.
But Lordship, this is the infringement of my fundamental right, Lordship.
It is not, sir.
Of my,
It is not.
Lordship, kindly, this is my right to livelihood.
You have taken this consciously. You have asked for this space on these terms and conditions.
On rupees 20, Lordship, I am ready to pay at the rate of rupees 20, which is reasonable, Lordship.
That is why the court is saying whether it can be enhanced or not, what will be the rate of rent, that is something beyond the scope of 226. And that is essentially the issue here. Whether they can charge the rate, they had charged 20, then they moved to 70. On protest, they reduced to 50.
Yes, Lordship.
Now, whether it is to be 30, 40, or 25, it's not for the writ court to determine. You will have to agitate before the appropriate court.
Lordship,
Where is your representation that you have made?
Lordship. Lordship, page number 30.
Page number
30, Lordship. Annexure P7.
the last order the court has recorded, you should have come with instructions in terms of the last order.
Grateful, Lord.
Whether they are food vendors, the other persons or not, that is not material.
Grateful,
The
Lord.
point is, the size of the shop is 9 times the shop that they are running.
And they have accepted it. And he has accepted that space, And since 2007.
When he accepted it,
He's not paying the rent also.
that's a different thing. When he accepted it, it was only 20 rupees.
So, on instruction I'm submitting, since 2011, he was paying rupees 20.
Correct.
2016, it raised to rupees 50.
Yes.
So after gap of 5 years, it is not that the next year only it has been raised. After 5 years, it was raised to 50.
Still, there has to be some semblance of logic and rationality. How can you charge 1,500 for 1 square meter open space and charge 1,000 from someone who is occupying 9 square meters just across the street? There has to be some,
Square meter, I think 3-4 square meters, and they have extended.
even if it is double. Talking to the conscience of the court. He must reconsider his. The earlier rent was being paid at 20.
Yes, Lordship.
Up till 16.
From July 16, it was paying the revision. It was revised to rupees 50. Since 2011 to
2016.
yes, June 2016.
It was 20.
From July 2016, it was revised to rupees 50 per day.
And that he has never paid.
And with an annual increase of 5%.
Why are you not depositing any?
Lordship, I have paid till the date when the rent was rupees 20 per day. And by this Honorable Court order of October, when the Honorable Court was pleased to take the comparative statement of both the respondents and the petitioner, the Honorable Court directed to pay rupees 1 lakh. Because since I am a defaulter, first you pay and then come before the Honorable Court. The petitioner complied with the order, paid rupees 1 lakh. And Lordship, kindly appreciate the statement, Lordship, that the comparative statement, Lordship. Accordingly, if we consider rupees 20 and a hike of at the interest of 5%, the annual rent due till date comes around 77,000, Lordship. I have paid rupees 1 lakh, Lordship.
So there is, before the court, there is only one vendor.
Pardon?
One individual is here.
Yes, Lordship. Only the petitioner has come before this Honorable Court.
So according to 20 rupees per month, it is
77,000 till date, Lordship. And the petitioner has already paid rupees 1 lakh by the direction of this Honorable Court. Lordship, this is the comparative statement of the rent. For the rent which is due, Lordship. According to rupees 20, with each year 5% hike.
no, but prior to that, there was no agreement of 5% hike.
Yes,
You
Lord.
cannot insist on
Yes, Lord.
5%.
Yes, Lord.
How are you saying since 2011?
There is no receipt, Lordship. There is from 2016 only, Lordship.
Space prior to that, not since 2016.
Have you received any rent prior to 2015?
No, the receipt.
This is your order of 3rd November 2015, where you yourself say that pursuant to direction of the Honorable Court on a hearing held on 2/7/15, the petitioners were given choice to identify a suitable place.
The fruit vendor's rent was rupees 20.
So therefore, it is not your case that he was liable to pay. He was liable to pay only up when he has come into occupation after 2015.
January 2016, Lordship.
That's January 2016. So for him, it is a case of jumping of the rent from 20 to
Rupees 50.
50 within less than a year, which is correct.
I'm grateful, Lord.
This is as per your own letter. What submission you are making contrary?
These are not the only vendors, my lord.
We are not concerned with the rest. We are not concerned with the rest. We are only concerned with the petitioner who is before this court. The facts which apply to him will only be taken into consideration. So what will be the rent if 5% is added from 15 till now?
Lordship, 29, Lordship. The company statement that I have submitted, according to 5% from 2016, Lordship, till 2024, the rent will 29, Lordship.
And as per that rate, the amount that you have paid will be insufficient.
No, it is more, Lordship. According to 77,000 is the due, I have already paid 1 lakh.
According to that, after adding that 5%.
Yes, Lordship. Yes, Lordship. It comes to 77,000. I've already paid 1 lakh, Lordship.
To ask the chairman to pass an order on his representation in light of the observations made by this court. And let the order be passed within 4 weeks. Chairman has to pass or the secretary? He has addressed it to the chairman. But I think the executive functions are probably being discharged by the secretary of the council. Who is
The chairperson is the head, Lordship.
No, he is the head of the body, but who discharges the executive functions?
Secretary.
Secretary must be doing it.
Secretary.
Let him decide. The To page 20. And whereas in the hearing held on 28/10/15, it was informed by that is suggested 4 places, thereafter he has taken possession. This is the question. This is your part of your
There was the construction of new RCC shop rooms. For that
whatever
reason,
it is.
they were relocated to a different place.
Picking an issue with such a person.
Right, Lordship. Grateful. Good.
It will be open to the petitioner to assail the order.
Item number 24. WPA 8, that is
Matter-
23.
My lord, I was to get back, my lord, with information, my lord, as to the status of the proposal for amendment of the recruitment rules. Because it was their contention, my lord, that the recruitment rules were required to be amended. And my lord had directed me to take instructions, my lords, on the status. So, my lord, I have received this, my lord, I have a photocopy, I can file it by way of affidavit also. Here, my lord will see. Sorry, it is marked, my lord, because the department has given it to me like this. Resolution number 136 dated 23rd August 2017. So, my lord, the resolution records that council did not agree to amend the existing recruitment rules for the post of community organizer and decided to continue with the existing notified RRs as recommended by the RR committee. This is signed by the chairperson of the PBMC. So, my lord, as stated in the affidavit in opposition, if my lord sees the status in the affidavit in opposition, page 4, paragraph 8. At that stage, my lord, we had stated that the amendment of RR for the post of community organizer under the council was returned with the observation to route the file to administrative branch of urban development. Now, subsequently, that proposal to amend has altogether been dropped. So, my lord, that amendment is not happening, my lord. And the prayer, my lord, if my lord sees the writ petition,
This is a resolution of 17.
17. This is the latest, my lord's position. And kindly see, my lord, the prayer in the writ petition, which is at page number 19 and 20. 20, the main prayer is prayer C. A writ or writs in the nature of mandamus do issue directing the respondent number 2 to publish the amended recruitment rules for the post of community organizer.
No,
In
no, so
official way.
therefore the court's observation that this based on this file noting, he cannot make out it.
Yes, so basically, my lord,
This
he-
was a decision making process which has led to this decision.
resulted in a decision not to amend altogether. So, my lord, the writ is not.
If
that's
at all you want, you can assail this or you can.
That decision, if he wants, that's a
This is
separate.
again a file noting.
No, I am
Again,
informing
if I-
the court. There was an instruction to inform the
No,
court.
it is not. It is a resolution of the council.
The
It's not a
resolution
file
of the
noting.
council.
It is a resolution of the council.
Now, earlier resolution has been cancelled by the.
This
I'm
is the
asking-
current status on instructions.
Where is the earlier resolution?
Yeah.
This is the
Can you have
current
a look
state-
at this page?
At page?
Just look. Page 36.
the note.
This is not, that's why I asked him. This is a resolution.
No, I'm coming to that one.
No, you said the earlier resolution. Therefore, I asked you to show where is the earlier resolution.
Yeah. Page 44, I just see. Page 44,
Yes.
annexure P6.
Yes, what is the resolution?
Council unanimously resolved.
Page 44.
44.
Sorry,
Number 11, 111.
Agenda
Resolution of urban poverty alleviation
skip
of the council amendment of the recruitment rules for the post of the community organizer under council. Agenda note this, project officers, next 24, project officer PBMC stated that the poverty alleviation program is being implemented by UPSL in view of the office order number such and such with the approval of the honorable lieutenant governor and islands. According to the approval.
उसके बाद वाला है, when you
हाँ.
see the next one.
Next, council resolved the approval to approve the draft amended recruitment rules for the post of community or organization born in the establishment of the Port Blair Municipal Council with the agenda note and resolved to send to the KN and decision for approval and the gazette notification as in Annex D.
So administration sent it back saying that in paragraph 4, my lord, was
Through
applicable.
the administration.
So administration has sent it back saying that you route it through the administrative branch of urban development, and later on, my lord, decision was taken not to amend altogether, my lord. This is executive decision, my
There
lord.
is something wrong. This is not later on. This that you are handing over is of 2017.
My lord, I think this is the heading, my lord. I can ascertain, but this appears to be the heading.
No, it is a resolution dated 23/8/2017. Cannot be later on after this 27/11/2018.
I can file an affidavit, my lord.
File an
It's
affidavit.
better that I file an
Yes.
affidavit.
Then up.
No, the first direct
No,
was
in
issued
this
for the
case,
first
in this
time.
case,
How
why
can
we
the
have
first?
filed? After 3 and 3 directions, they have not filed the affidavit in opposition.
All the next case.
Item number 25. WPA 240 of 2022.
I pay for respondent.
Extension of time to file everything that like what 2 weeks.
Time for filing affidavit in reply.
Item number 26. WPA 22 with item number 27.
Should I senior office in this matter? Trainer makes it.
As prayed.
The petitioner one. There is a direction upon the respondents to file affidavit 18 November.
But also in this particular matter, Samantha is appealing the private respondent. We have filed 2 amicably appeal, Your Honor, along with the can.
To what appeal?
Two mandamus appeal was filed against the November 18 order,
Number 18 and 14.
but it was not listed.
November 18 order passed in this proceeding.
This proceeding an order was passed. Sealing is hotel.
So his hotel is sealed.
Yes.
Let him take.
Against this, he filed the appeal, but he is not filing affidavit in terms of this order.
While the appeal is pending, why the court should be in haste? The appeal is filed, let the appeal be considered. His hotel is already sealed.
The construction is absolutely illegal, my lord. Already the demolition order is
So
there.
he is not able to utilize.
Well, let him file
What
the
is the
affidavit.
appeal number
71 and 72, Your Lordship.
of 2024?
Your Lordship.
Filed 1 month before.
Appeals bearing number 7.
Item number 29, WPA 485/23 with item number 13.
We've seen your pains for next one.
Yes.
Item number 31, WPA 890/23.
31, I am seeking extension of time to file opposition, my lord.
All right.
31. 31.
Time to file affidavit in reply is extended by 2 weeks.
My lord, I am appearing on behalf of the petitioner in this case, my lord. My lord,
Opposition.
on the several occasions, my lord, they are taking time from your lordship. They were peremptorily directed in the month of November to file written objection, affidavit of opposition, my lord. They have not filed it.
Chance has been
On the
given
last occasion also, my lord,
and last chance.
there is a serious matter of fraud which has been committed, my lord, in this case. From the three authorities, they have
Just wait, just
they have provided, my lord, my lord. এটা খুলে গেছে।
Where is the peremptory order for filing affidavit? What is?
My lord, order. My
Yes,
lord, ordered November, in the month of November 14, Lordship Justice Raja Shekhar Mantha has passed an order, my lord, November 14, 2024.
who are 1 to 6?
The respondent number 1 to 6 are given a last chance and peremptorily to file affidavit in opposition within 10 days from the date. Now, Lordship, their authority has committed a fraud with keeping a close nexus with the
Chasing on
private
merits.
respondents, and now, my lord, they are seeking time.
My lord, 1 to 6, I am
My lord.
appearing. One last chance may be given.
Who are they?
Revenue
My lord,
department.
peremptorily, my lord, they were directed to file the
Let them shed some revenue
opposition.
proceeding. What is this? 1, 2, 3, 4, 5 orders after last chance.
My lord, one chance may be given. We have
By
received.
way of
the-
last chance. The respondents 1 to 6 were directed to file affidavit in opposition on 14/11/2024. Thereafter, the order sheet reveals that the matter has been taken up on 3 dates. That is on 11/12/24, 12/12/24, and 9/1/24, prior to the matter being taken up today. Today is the 4th occasion after the last chance was granted to the respondents 1 to 6 to file an affidavit. And today again a prayer is made for granting an adjournment for filing affidavit in opposition. Stop. Since the last chance was granted much earlier and the respondents 1 to 6 have failed to file the affidavit in compliance of the order dated 14/11/2024, till date, the authorities are granted last chance, now subject to payment of cost rupees 10,000
My lord, cost
in
may
the
not
Legal
be.
Services Authority. I am so grateful, my lord, for your lordship's
My lord.
exhaustive direction, my lord. I am so grateful.
Not the way, sir. Can't be so casual.
My lord,
Deeply obliged, my lord. Deeply obliged.
Yes.
to substitute the respondent number 6,
Yes.
the petitioner has not taken any steps to.
Why did you not
Respond
comply
number
with the
7.
order? Why did you not comply with the order? That is the only issue.
And
Is this the way?
Monday we will file, my lord.
You will not be doing anyone a favor.
No, my lord.
You
I'm
are saying
just
as if you are
undertaking to file.
assuring the court that I will do it. Either you are
I
required to
undertake to file.
comply with order
As
or you are required to take remedial measures.
my lord, we
You
sir.
cannot sit over the
No,
order.
my lord, we have received the paragraph
That the
comments,
court
my
does
lord,
not
we will.
appreciate.
It's under preparation, my lord. I will file in 2 days.
6 respondents, what is 10,000 rupees? Nothing.
My lord, it will affect our, by Monday we'll file, my lord.
Wrongly appeared. Item number 33, WPF 425 after 24.
Mr. Advocate on record in this matter is Mr. Ajit Prasad, by Senior Counsel Deepchand Kabir. Ajit Prasad is mainland. His wife is undergoing for treatment. Yesterday, a minor surgery was, so let it be next, sir. On behalf of
Item number 34, CRR 27 of 2022.
My lordship, in this matter, my senior is appearing for the petitioner. I pray for next circuit, Lord. No, Your Honor. The other side is not here, is not well. The respondent counsel. Due to some personal difficulty, he's not in the compass, Your Honor.
Lord, I beg pardon. Here also Ajit Prasad is there for responding.
My lord.
Item number 36, CRR 8 of 2024.
Where is- Jaypal appears for the respondent. Let it be next circuit adjourned.
My lord, is gone to, my lord, take the printout.
আর এই মেসেজ করে জয়েন করতে বলছি চ্যাট বক্সে হবে না
He's my friend has his number, he can share it with the court officer. Phone you ask him to join.
My lord.
Actually, he is in receipt of the instructions, so it'll fall on the council. Let him file the affidavit. He'll file it by Monday.
My lord, as whatever falls from you, my lord.
Yes.
Whatever. Only, my lord, I need to assist your lordship that what is their conduct with the record, lordship, that I have brought on record, my lord.
So it remains to be heard on the merits. It remains to be heard. Where is he? Let him come. The I don't want to record the order in his absence.
We tell him that my lord is trying to get it out quickly, otherwise maybe he's trying to print it out.
Tell him that it must be done by Monday. Ask him to come. Read the order that just read the order I dictated.
My lordship, that case, lordship, mental ability issue regarding.
Tomorrow you don't want tomorrow. No, I won't be available in station. He will point out tomorrow. Fine. I'm the